Good morning, everybody, and welcome to our webinar. Today, we would like to thank Janusz for joining us once again. It's a great pleasure to have you with us, Janusz, and it's a great pleasure to welcome all of you as panelists to our event today. So we are ready to proceed to our webinar, and it gives me great pleasure to introduce to you today Janusz Luterek from Hahn & Hahn. Janusz has a degree in both chemical engineering as well as law. He's a registered attorney, a patent attorney, as well as a professional engineer. He's a partner at Hahn & Hahn, and he's a custodian member of SACFOST, and he also sits on the Food Law Advisory Group at the Department of Health. So he's really in the know as far as food law is concerned. And as always, Janusz, it's great having you. We'd love to welcome you to this webinar.
Thank you very much.
Janusz, today I wanted to chat to you about liability again. I know we've chatted about it once before, and I know it comes up on most of our conversations, but when we look at the legal proceedings that are even a further discussion today in the press with regards to the case brought regarding the listeriosis outbreak, it obviously makes everybody in the food industry sit up straight, because a possibility of liability is a very serious thing. Regulation 638 also puts additional focus on the person in charge having to be qualified. So from that perspective, I thought it would be a good idea just to make sure that everybody understood exactly what do we mean with regards to liability, personal liability, product liability, at all levels. So I'm looking forward to you taking us through, what liability actually means in terms of food safety.
All right. So I think just to kick off with is that, this is a very important topic, this liability for food safety events. And what I mean here, I don't mean parties. I mean when something goes wrong and people get ill and so on. In the recent while, I've been asked quite a number of times by people in meetings, so what is my personal liability? How can I be held responsible for something my company does, or my company tells me to do something? How can I be liable? And I'm going to try and explain that today in this short presentation.
Thanks, Janusz. Obviously, you're not giving us a specific legal opinion. This is just a general advice. So everybody, please take note of
Linda, are you there? Can you change the slide?
Yes, I have done.
There are different types of liability, and these need to be understood in order to realize what is your potential liability as an individual. So the first thing we have is a so-called criminal liability. So that's an obvious one. Most people understand that. That's the one where you can go to jail or you can get a fine. And typically, there are criminal provisions in the Foodstuffs, Cosmetics and Disinfectants Act. And lately, that includes quite a number of provisions in Regulation R638, the hygiene regulations, if you're the person in charge of premises. We then have the Consumer Protection Act, and finally we have criminal liability under the common law for something like manslaughter or culpable homicide. You can kill someone with a gun, but you can equally kill them with food. Therefore, those crimes would apply equally. We then have civil liability. So civil liability is when somebody claims money from you. This would be the actual harmed person or injured person. And there we have the Consumer Protection Act being the primary source of this liability. And then we have the common law again. And then finally, we have director's liability. So people that are in the audience often are technical managers or QA managers. Next slide, please.
Sorry, Janusz, I just think it's really important that we take note of the fact that it's criminal liability. Like you said, you can equally kill someone with food, and that's a really serious. It's really serious from that perspective.
Absolutely. I mean, we know now this illnesses. I mean, it's been in the press with how many people died from listeria and so on. So, okay. So let's talk about the criminal liability under the Foodstuffs, Cosmetics and Disinfectants Act, the FCD Act. And there, let's start off with the liability of the employer or principal. And what it says in the Act is that an act or omission of an employee, manager or agent which constitutes an offence under this Act shall be deemed to be an act or omission of his employer. So if an employee does something, it's deemed to be that the employer did that thing. The employer would be liable if the employee does something wrong. But that doesn't mean that the employee is not held responsible, as you'll see a bit later on this slide. And the said employer may be convicted and sentenced in respect of it unless he proves. So the employer can be prosecuted, the employer can be found guilty if he can't show that he did not commit or connive of such act or omission, that he took all reasonable measures to prevent an act or omission, or that an act or omission, whether legal or illegal, does not fall within the course of the employment of the employee that did this legal or illegal act. But what's very important is at number 2, an employer cannot say, well, we took all reasonable measures because we forbade an act or omission, unless all reasonable measures were taken to prevent such an act or omission. So it's not simply enough to say, but we have a manual and it's in somebody's office and it says you must wash your hands after you've been to the toilet. You actually need to take reasonable measures to prevent a person leaving the toilet without having washed their hands and going to handle food again. But as a private individual, as an employee, you need to note point number 3 on this slide, 8.3. It says the provisions of subsection 1, in other words, the part of the law that makes the employer criminally liable for the acts of an employee shall not be deemed to relieve the employee from liability to be convicted and sentenced in respect of the act or omission in question. So what this says is, yes, as an employee, your actions are the actions of the company and the company will be prosecuted. You will also be prosecuted. That's what 8.3 says. If a crime has been committed, the person who commits the crime and the person who permits the crime to be committed shall both be prosecuted. Very, very important.
Now, Janusz, if I can, at this point, we're talking about the employer or the principal. I'm assuming that are you going to clarify what the difference is between the employer and the person in charge? Because in some businesses, those could actually be 2 separate people.
Yeah, I think when I get 1 or 2 slides on, I'll talk about R638, and then we can talk about the person in charge, because in some cases, the person in charge is the employer, but in most cases, he's the employee.
Yes.
It's just the person whose name they've put on a certificate. And that person needs to understand that although his employer will be liable, under 8.3, that person in charge can also be held criminally liable. But
okay, so there are 2 levels of liability, that of the employer and then that of the person in charge.
Well, of the employee, that employee can be the person in charge, but it could be another employee. It could be just a food handler.
Yes, no, I understand that. But in this case, when we talk about the employer or the principal, this could be the person who owns the business, but then they could have a manager who runs the kitchen. So it could be 2 people, but depending on the size of the business, it could be 1 person.
Absolutely, no, absolutely, you're correct. Yes. Okay. Let's talk about another level of liability, which is the liability of the importer, manufacturer, or packer. And I think the key word there for most people is the manufacturer, but of course, all 3 are important, importer, manufacturer, or packer. And then it says, the person who, according to the label of any foodstuff, so if your name is on the label, it says packed by, or manufactured by, or imported by, which is sold in a sealed package and which does not comply with the provisions of this Act, or imported, manufactured, or who imported, manufactured, or packed the article in question, shall be presumed to have imported, manufactured, or packed, as the case may be, such article, and here comes the kicker, may be convicted and sentenced accordingly. So if there's something wrong with the foodstuff and you are the importer, the manufacturer, or the packer, because of the label saying you are the importer, manufacturer, or packer, you can be convicted and sentenced in accordance with this section, bearing in mind that this, of course, would be the company, not the private individual. And the only way that you would be able to avoid that would be if you can show that you didn't import it. In other words, you can prove that the label is wrong. I don't know how you would do that, but presuming you can. That the non-compliance of such an article with the provisions of the Act is due to deterioration or some other change which occurred after such article left his possession and over which he had no control. So you're an importer or the manufacturer, and what happens is you now supply a retailer and it's incorrectly stored at the retailer, and when there's a food poisoning case, they now say, well, you're the manufacturer, so you're liable, and you can show that, no, if you look at our retention samples, you look at all our production records, the quality control records, there was nothing wrong with the product when we handed it over to the retailer. Then you would have a defense. But very importantly, 9.2 says, the provision of subsection 1 shall not be deemed to relieve any person from liability incurred by him in terms of this act in respect of the sale of any article referred to in that subsection. So, although this refers to the importer, manufacturer, or packer, a person selling that product can also be liable either together with these people or separately under the previous section we just spoke about.
Okay, so paragraph 9b then, 9.1b is really, really important if you're a manufacturer supplying the retailers, because it's incumbent of you to ensure that you can demonstrate when you lost control of the product, and it became the responsibility of the next link in the food chain.
So I've got a case at the moment where a client is being sued and potentially will be prosecuted for a product which was sold through a retailer. A consumer purchased it through a retailer and then claims they have got very, very ill. But my client says, but when we sold it to the retailer, there was nothing wrong with the product. We can show from our retention sample that actually the product was fine when it left our hands. We sold it. We sold it to the retailer a year ago. It's been in the retailer's hands for 1 year before being sold to the consumer. So that is where this defense in B will definitely come into play when we get to court.
Okay, great. So that's important, I think, in terms of your food safety management system. Okay, so let's look at the person in charge, because I've had lots of discussions with people who say they don't really feel like putting up their hand to be the person in charge anymore.
And let me start off by saying I agree with them completely. I think if somebody wants you to be the person in charge, you should be getting the big bucks.
Okay.
because you're carrying so much of the risk.
Yes.
And I think people need to understand this. Employers need to understand this. Is that when you can't expect someone to be doing a job which potentially could land them in jail for following instructions which they may not agree with, but not pay them the big bucks. But being less flippant, the people need to actually have authority and not be simply carrying out and rubber stamping what they're being told to do. But let's discuss this now in more detail. So the person in charge in relation to food premises means a natural person, so it's got to be a person you can pinch. Person in charge is not a corporation that's registered at CIPC, because that's not a natural person.
Yes.
Who is responsible for the food premises or the owner of such food premises, as the case may be. So it requires that a person is a real person, a human, as we would like to call it. That's the person in charge. Now, under 4.44 of the same regulations, it says the person in charge or his or her representative upon whom a prohibition order was served. The reason I put this up there is because in those regulations, when there is room to delegate something, then they've written it out. They've said it's the person in charge or his or her representative. In other parts of the regulations, they only refer to the person in charge, which means it's not something you can delegate. And it's a principle of law that when things are written differently in one law, they must mean something different. Otherwise, it would be written the same way. If it was the intention throughout that you could delegate your obligations and your responsibilities, then everywhere it would say the person in charge or his or her representative.
Sorry to interrupt you, but from a practical perspective, Janusz, what does the person in charge do if they go on leave, or they're simply not present that day because they have to attend a conference or they have to attend training? What would happen in that case?
No, look, it's the same as a pilot of a Boeing 747 who has to go use the bathroom or goes to have a rest and he leaves his co-pilot in charge. If there's a problem, they need to be able to get hold of that person, and that person would then need to be able to make a decision on what needs to be done. The key thing here is that when you have people working for you, I don't want to use the word delegate. You're the person in charge and you have people working for you. They need to be adequately trained and in a position to deal with issues if you are going to leave them with the responsibility of doing that, because if things go wrong, it will ultimately come back to you. I hope that makes sense.
Yes, I think it does, and I think I think what you're saying in terms of there could be someone who's given the responsibility of deputizing, but ultimately, if there are important decisions that need to be made, the decision will be in charge. Is that correct?
Yes. So I mean, in any company, there's a managing director and a CEO, and there are people that work for them. If one of them goes on leave, the company doesn't close till they get back. But the structure that they have put in place, so that must run while they're away. Now, you have a responsibility to ensure that the structures you put in place will be adequate and that there are contingency plans in place for should something go wrong. You cannot just expect the person you've left behind to just take over and run the place without you, otherwise why do they need you to come back?
Sure. So it's all about then demonstrating the arrangements that were made and being reasonable in that respect. Now, we see in the new regulation that this person has some additional responsibilities. Yes.
So since the coming into effect of this hygiene regulation as opposed to the previous R962, it's become quite clear that the person in charge has extended responsibilities, and regulation 10 runs up to, I think, 18 sub-regulations. But to me, some of the most important ones are in the beginning, where it says that you have an obligation to ensure that you are suitably qualified. You then have an obligation to make sure that the people who work for you are suitably qualified. Now, those are very, very important things, and in fact, they may be the most important things that the person in charge has to do. Because without being suitably qualified, can you or the people who work for you ever ensure that food is safe? That person then also has this issue of making sure that there are routine assessments, determining when further training has to be done, and then to keep proper records of all the training. And this D is actually in your own defense as well, because obviously if you've been doing all the training, you can teach somebody, doesn't mean they can learn. There's a difference. But at least you're going to have records to show that you have done everything which is reasonably possible to ensure that the people are suitably trained. And I suppose if they can't be trained, you have to do your labor law thing and move them along. You can't just put somebody in a position dealing where they could potentially poison millions of people for the food stuff and not be able to move them along if they're unable to absorb the training of what is food safety.
Now, if we look at this and we link it back to the Act, in the Act you have the principle It would obviously be the requirement of the principal to ensure that the person in charge has been trained, or to provide the resources to allow them to be trained, if the principal and the person in charge are not the same person.
Yes, you're right. But I think what's important is that the actions of the person in charge will be seen on their own, and the actions of the employer or principal will be seen on their own. So if the employer is not providing the correct or sufficient resources and support and so on, they will be held to book for that. But as the person in charge, if you remember what that Section 8 in the Act said, you cannot escape personal liability.
Yes.
You would be held liable together with your employer for not carrying out the requirements of the Act and the regulations. And therefore, as was shown in the Nuremberg trials after World War II, you cannot simply say, but they told me to do it, so I did it. If you find that you're unable to comply with the law because of what your employer is doing, you have to either invoke grievance procedures under the labor law, and I'm not a labor law expert, but certainly I know of grievance procedures. And in the worst case, you may have to resign and sue the company for constructive dismissal or grounds like that. But you simply cannot go along with it and then shrug your shoulders and say, oh, well, I've got a memo, it said I must do it. I don't know if you remember at that one talk I did in Port Elizabeth, where I read out the email I got from the client, from a member of the food industry, that said that in their employment contract, it said that they have to take all the food every day and reuse it the next day. I don't know if you remember.
Yes, yes.
Yeah, so that would be unacceptable. You can't say, well, they told me to do it, so I'm just going to do it. If it's not safe, it's not hygienic, it's in contravention of the law, you simply can't do it.
Yes, and it would then be my responsibility as the person in charge to demonstrate that I have brought this to the attention of my employer. It's in writing. I followed the proper channels in that regard, and if there is constructive dismissal as a result of it, it's that evidence that would then accompany me to the CCMA in order to demonstrate that I was in fact just acting within the grounds of the law.
Yes. And I don't know if you've seen in the press these stories about the building that burnt down in Johannesburg, and
yes.
where the union was saying, but we actually warned the department that this building is a death trap, and their reaction was to dismiss the people who complained.
Yes.
So unfortunately, it happens. You get employers like that. And
yes. No.
As an employee, you will have to make the choice. Are you going to run the gauntlet and carry out the illegal instruction, or are you going to do something about it? And that's unfortunately within each person to decide.
Absolutely. Now, in terms of the person in charge, I think the next paragraph that says the provisions of these regulations should be complied with and the conditions are not performed and permitted on the premises. It's these paragraphs within the regulation that underline the importance of the fact that the person in charge does need to be physically present at the premise.
Obviously, nobody can be present 24 hours a day, and some factories run 24 hours a day. But at the end of the day, certainly I would not advocate a situation with someone in an office 1,000 kilometers away that has never been to the plant, maybe once in several years, is the person in charge, and there are people on the ground running the plant, because when things go wrong, that person who's never been to the plant will have to answer as to how he ensured that the provisions of the regulations are complied with, how he ensured that the condition, act, or emission that may contaminate food did not arise or was not permitted, etc., etc. So this burden of proof will fall on this person to show what was he doing to ensure that all of this is complied with. And remember what I said earlier, it's insufficient to say, but it's in our standard operating procedure, it's on the shelf in the manager's office, in the plant manager's office. There has to be an active involvement in ensuring compliance.
So your point The point about a 24-hour operation, again, the person in charge would need to make sure that there's adequate supervision for day shift and night shift, that those people are aware that they are assisting in actually executing the legal requirements, but ultimately he or she would still be responsible even for the night shift activities.
Yes, but obviously, if they are able to show that they are actively managing it, they have staff meetings, they review things, when there are non-conformances, what do they do? Then, of course, they wouldn't be guilty of any criminal offence. I mean, they certainly can't be expected to be on the job 24 hours a day. But as I'm saying, it wouldn't be sufficient to simply say, but we have SOPs, and when staff arrive, when we hire new staff, we tell them where the manuals are. That
Yes.
would not be.
Absolutely. No, absolutely. Okay, so in terms of the fines, who's going to pay the big bucks and who's going to jail?
Well, as I pointed out earlier, that there are two levels of liability. So the employer, I presume in the first instance, would be prosecuted, but under the correct circumstances, the actual person in charge who didn't take his job seriously could likewise be prosecuted. So there could in fact be a double prosecution. You could have the company being prosecuted and the private individual whose job is person in charge, and they could be either fined or even face potential imprisonment. So, it definitely impacts on both the actual natural person in charge and the company. And by the way, not under R638, but under the previous I think it was the R918 before it became R962, I did defend actually such a case in KZN, where the manager of a butchery and the store manager were both prosecuted, effectively one on behalf of the company and one because it was his specific responsibility to do something which it was claimed he hadn't done.
Okay. So again, in terms of my defense as the person in charge, I would then have to be able to show that I've done everything I can and I've brought it to the attention of the company if it's something that is now out of my control, or my boss goes over my head, or the company doesn't provide the appropriate resources.
But then you've got to show that what did you do to try and deal with the problem, if you know what I'm saying.
Of course.
I suppose essentially be a whistleblower. Okay,
sure.
So let's move on to the last type or the next type of liability, and that would be under the common law for what I would like to call culpable homicide. I think most people understand that, sometimes referred to as manslaughter. I don't want to call it murder because I don't think anybody, so far that I know, nobody intentionally sets out to kill a lot of people with botulism or listeria or something. But culpable homicide is a different story, because the definition of culpable homicide is the unlawful, negligent killing of a human being. What is negligent? Negligent means failing to take proper care over something reasonably foreseeable, and it can be done by a natural person or an entity, and both can be guilty. So in the mining industry, you've had people charged with culpable homicide over mining accidents, where the proper safety gear wasn't in place, safety gear wasn't adequate, there wasn't enough safety gear, and when there were rockfalls, people died. And you've got private persons being prosecuted as well as a company. And it could be the same in the case of a foodstuff. So if a foodstuff goes out, and due to some or other negligence in the company, the food is unsafe to the level that someone dies from it, or many people die from it, there could be a prosecution under culpable homicide. And those of you who watched Oscar Pistorius would know about dolus eventualis and all the other various forms of the difference between murder and homicide. Then finally, under the Consumer Protection Act, a private individual cannot in fact be fined. This would be a fine for the company, and it would be actually an administrative fine, which is not really a criminal thing, but it falls in that category. And those fines can be up to 1 million rand or 10% of your turnover, whichever is greater. But that would be a fine typically in the case of a company which repeatedly allows the same type of thing to happen without taking appropriate steps to protect the consumer.
Okay, so in this case, there's no personal liability specifically, but it would be, if it's my company and the company is registered in my personal name, then obviously the two are one. But if I'm separated from my company either by a PTY or previously registered, closed corporation, then it would be the company's liability, not the individual's liability.
Yes, that's correct. That's correct.
Okay. All right. So in terms of the Consumer Protection Act, obviously you now have civil liability issues and the complicating factors of vicarious and strict liability. What does all of this mean?
Okay, so I didn't want to make this a talk about the Consumer Protection Act because we've dealt with this many times, and I presume that most people by now know what this means. But strict liability merely means that you are liable if your product harmed the consumer. There's no question of negligence. It doesn't matter whether you thought it will harm the consumer, didn't think it will harm the consumer, or for that matter of fact, what extent you went to make sure nobody gets harmed. If they still get harmed, you will still be liable. When I talk about liable, I'm talking here about money. Somebody will sue you. You've seen with the Listeria case, they're talking about several million rand per person who died. So we're looking at a couple of billion rand for the claims in the Listeria case. But the strict liability on the face of it would be a claim against the company. And then when it goes near the end of the Consumer Protection Act, there's a section 113 with this title, Vicarious Liability. So vicarious liability means that you are liable for the actions of another person. And it there says that if an employee or agent of a person is liable in the course of their employment or activities on behalf of their principal, the employer, then the employer or principal is jointly and severally liable with that person. So what does that mean? Well, it's not written as clearly as I would have liked it to, but what it's definitely saying is that if in section 61, the actions of a person led to the harm, then that person would be liable together with the company who he works for to the consumer that sues, because it says jointly and severally liable. Now, it may of course be that the company pays out the consumer and then the employee doesn't have to pay anything. But the consumer could go after the employee if he knew who it was and the company jointly. And unfortunately, they were very clear and they say this does not apply to criminal liability. So under the Consumer Protection Act criminal liability, not under the Foodstuffs Act. Foodstuffs Act is dealt with. This is the Consumer Protection Act. So if you've committed a crime under the Consumer Protection Act, then a private individual cannot be liable together with his company. The actions of the person become the actions of the company.
Okay. So in this case, I mean, if you had to have a practical situation where the employee was in fact found to be responsible, it is likely that that individual would, after the company is paid, it is likely that that person would be dismissed.
Sure, it could even be that the company then tries to recover their money from that employee. I've heard of cases like that. But bearing in mind, in our legal system, if you went to the court, you'll get a court order that says these two entities must pay the consumer. Number one, name of company. Number two, name of person. The consumer who is owed the money, he doesn't have to try and get it out of this private individual. He'll get it out of the company, and then it'll become the problem of the company to get the money out of their employee.
Yeah. Okay, so these are very sobering discussions. So now I think if we take where we've come to, we've definitely spoken about the food safety team leader. So in any food safety management system, we normally appoint a member of management who's responsible for the food safety system. And I think you've dealt with, what do I do if my boss goes over my head? And what do I do if I'm in a situation where the company is not, complying with the law? It's my responsibility to make sure that this is put forward, and it's my conscience at the end of the day. But what about the fiduciary responsibility with regards to directors? So I'm the risk director or I'm the technical director. I'm responsible for guiding the company with regards to policy and risk management. how am I personally affected because of the fact that I have director after my name?
Sure. So this is really important because often directors are actually quite removed from what's happening on the ground, especially in big companies. So what happens is the board of directors looks at financials and they make decisions. They put a 3-year plan on capital expenditure. They're not dealing with day-to-day problems of a metal detector on a line where a blade can go through and end up in a loaf of bread. But their decisions impact on those day-to-day things. So the director must make decisions which are in the best interest of the company, and of course it's in the best interest of the company not to be sued for having poisoned people or harmed people in some way. So this is where the liability of the directors arise. A second part of liability that arises is if I'm a shareholder, and I haven't spoken about that yet, but I think we need to say that. If I'm a shareholder and I had R1 million worth of shares in a food company, and there's a food safety event and now those shares are worth 500,000 rand, I as a shareholder may in fact have a claim against the directors for allowing that event to happen, if that is the case, because those directors' action or inaction has resulted in my direct losses and investment. So directors do have a liability, and the liability is from various directions. It's not under the FCD Act and it's not under the Consumer Protection Act yet. I think what's important is to understand that a director can be liable to a fine or imprisonment as well in terms of this act. And this could be for anything under the control of that director which they negligently or intentionally didn't do, which should have been done. So, you know, I often hear this where I say I'm talking to a company and they say, well, you know, the scanning equipment that checks for metal at the end of the packing line has been broken now for 3 months, 4 months. We're struggling to get parts because this machine is so old. And we've been telling the management that we need a new one, but they say there's no money in the budget.
Yeah.
Now, that's a very interesting one, because if I was representing a consumer who had died or people who got ill because of this machine not functioning, and it wasn't, and the excuse given to me was, well, we didn't have money to replace it, I would subpoena their financials and I would say, well, let's see, where did you spend your money? There was a
well, that big fancy Merc in the parking.
Directors buying first-class international travel, but you didn't have money to buy something which is essential to food safety, and you're a food company. So these are things that companies will have to take very, very seriously. For example, unhygienic equipment design, things like that. So you're buying equipment on price and ignoring the fact that it may not, in fact, be fit for purpose from a food safety perspective. It will make the product, but it's not ideal for food safety.
No. So what we're actually dealing with now is corporate governance. You know, we're actually taking, you know, food safety to the board level, and we're actually needing to make food safety risks parts of that corporate risk committee's agenda, and making sure that there's good communication from operational management all the way through to directors, because if we're not telling the directors the resources that we need, they can't then be blamed for not making it available.
No, and what's important is the directors must be helped to understand which of the things are really important and which are nice to have. Unfortunately, on many boards, and I say unfortunately, but on many boards, the directors are accountants, they're lawyers, they're not food technologists, they're not microbiologists, they one or two maybe chemical engineers, which would help, but in very few cases are they able to simply by looking at generic documentation, budget information, identify that this is crucial and this is not. So it has to be brought to their attention. Of course, the risk of bringing that to their attention is, of course, now they know. So if you like a memo, I don't know how many of you ever saw that presentation by Bill Marler, the one about Jack in the Box, where the employee wrote a little memo and said, I think you should cook the burgers another I don't know, 10 seconds or whatever to cook them through properly before you serve them. And nobody read it, or they sent in like a generic thank you for your good suggestion, and no one ever put it again. And that is the risk. So when employees in a company make suggestions to the board, we need to change the sausage filler because it's impossible to clean. Those directors are now immediately at risk, because if they don't do something now to fix the problem, and it does become a big issue, they will be held liable. You could face imprisonment because they negligently allowed somebody to die, who then died from the sausage which was made with this unhygienic equipment, and they knew about it. And the key thing here is, and they knew about it.
Yes, absolutely. Absolutely. They can no longer plead ignorance in that respect.
Yes.
Okay, so if I take the final questions that I have, I wanted to just understand, as the quality manager in a company or the microbiologist in a company, what should I do if I make a decision and I'm responsible for releasing the product, and in my professional opinion and in accordance with the specifications, the product is unsafe, it should not leave the premises. And it's my authority to make that call. I have that authority to make that call. It's part of my job function. But then I'm overridden. So somebody higher up the chain says it's going to go regardless. What should I do?
Very importantly, we need to place on record, by writing a memo or a letter to senior management, to say, I advise that this should not have been released, but I was overridden by sales or marketing or whoever it is that normally makes those bad decisions. And so that's because obviously you're a food technologist or a microbiologist in middle management. You don't have the power to actually prevent it. But certainly you have the power to say this shouldn't go. If somebody else then makes it go, well, then that's their liability, not your liability. But you need to record it so that they don't turn around later and say, but we never understood you to have said this shouldn't go.
Absolutely, I agree with you. I've told many people that it's important to practice CYA. Cover your agterend when it comes to your, as a quality manager, as a food safety manager, you have to put it in writing, and you have to make sure that the right people do know about it. It does sometimes make you very unpopular, but I'd rather have that than have a culpable homicide criminal record, associated with my name.
I think people must understand that we are entering a whole new world. This listeria case has changed everything. In future, you're going to find when cases like this listeria case occur, there will be prosecutions. I think they weren't ready for it. They didn't know what to do. They didn't prosecute anyone yet, as far as I know. But I know the next time something like this happens, they will be ready for it. They will follow the correct procedures and they will prosecute people. It's not just going to be recalls and people suing companies. People will go to jail.
Yeah. I have to agree with you, Janusz. I think that is definitely the case. I'm aware that there are a number of culpable homicide sentences that have been handed out in the UK. I mean, America, we obviously understand because there's, it's one of those countries. But I know recently that there have been some sentences with regards to culpable homicide. I understand that we have an all-important flag meeting this week.
Yes, on Thursday morning.
And we sincerely hope that our next webinar we'll be able to chat about the developments in the new micro regulations, because hopefully we will have some clarity.
The problem is we're not at liberty to discuss what happens at the flag meeting. They are confidential, but they do sometimes release sort of updates from those flag meetings, and then obviously we would be able to discuss it. I'm personally raising some issues and clarifications of R638, such as what is accredited training, some HACCP-related questions from the HACCP regulations, and hopefully we'll get some clarity.
Yes, absolutely. In fact, with regards to specifically with regards to accredited training, I'm quite interested to see whether the definition from 961 on the milk shed will be carried across to 638, because the paragraph in Regulation 961 is almost identical to the paragraph under the new 638, and the definition of accredited is included in that regulation. We have had some feedback from the department with regards to accredited leaning towards a university qualification, or a level that is the same as a university qualification. And I just wonder how that will actually be practical, given the fact that this regulation has to be applied across the board, including very small companies and even street vendors, I think. I'm not sure whether that's going to be whether that's going to be entirely practical. So I look forward to those updates if you can.
No, sure. No, I think that won't be something that they will object to being discussed. So I'm pretty sure that they will allow us, if there's anything that they come up with, to give feedback on what is accredited training.
That's great. Thank you, everybody, for your time. Janusz, thank you so much for being with us. It was an absolute eye-opener. We are going to make a big deal about this webinar, because I think there are a lot of directors and managers and food safety managers, operations managers, lots of people that sit in fancy offices that actually need to fully understand what they're in for. And as you said, Janusz, it's never going to be the same again. So it's really time to brush up on our knowledge of the legislation, and more importantly, our knowledge of what we're personally liable for. So thank you again for sharing your knowledge.
It's a great pleasure. Thank you so much.
Thanks, everybody. Have a good day. We'll see you next time. Don't forget, you'll receive a link, and the presentation will be loaded onto our YouTube channel and onto Janusz's YouTube channel within the next few days. Thanks for being with us. Don't forget to take the survey. See you later.
Thanks a lot. Bye.